Welcome to the ARPA Benefits Compliance Updates and FAQ, Session 4. Thank you all for joining us. Our Benefits Compliance team will be moderating today's call, led by Patrick Myers. At the end of the call, please post your questions in the Q&A as opposed to the chat. We'll try to get to as many of the Q&As as we can in the time allotted after the main discussion. As you may have seen in our communication from the previous weeks, today's call has been extended to 1.5 hours to ensure that we cover all of the material. If you are unable to stay on the call, today's presentation is being recorded and will be emailed out tomorrow. The recording and the slide deck from this webinar will be posted to the nfp.com latest insights page under webinars/training. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Beth Allen, Vice President and Counsel, and Diane Cross, Vice President and Counsel from NFP's Benefits Compliance Department. We're very excited to have them speaking with us today, and it is my great pleasure to hand the call over to our speakers. Diane, the floor is yours.
Well, thanks, Leanne, and welcome everybody. Thanks for joining us again as we discuss the compliance considerations as a result of the ARPA. I will say that while we have so much to talk about that it merited an additional compliance webinar, that stay tuned on whether or not there will be a part 5, so to speak, if you will, depending on if we get further additional guidance or as compliance considerations come up that would need an additional webinar. So a few housekeeping items before we get into today's content is our friendly disclaimer. So please note that the following is intended to be used for general guidance purposes only. It's not intended to constitute tax or legal advice. Any question of application of the law should be addressed to legal or tax counsel, and the information is current as of today. So with that being said, Beth and I hope to cover over the next hour and a half a review of the compliance guide as it relates to the ARPA COBRA subsidies. In addition to that, we want to add in some practical application of that step-by-step analysis on how it impacts certain employers and the common questions that we've been receiving regarding compliance. And then we will go into one step further and discuss the frequently asked questions that we're still receiving on the COBRA subsidies, FFCRA leave, and the DCAPS changes. So that being said, let's review the step-by-step guide to compliance that we introduced, if you were with us last week, on the ARPA COBRA subsidies. So step 1, and really as background, what I should provide is that we are trying to package the information in a way that is easiest to understand, although nothing about this is easy, and to put in a logical order or method into what compliance means under the ARPA as it relates to benefits compliance matters. So that being said, we have kind of organized the information in a step-by-step guide, thanks to Joe and Patrick, who did that last week, and we'll reiterate it, and it kind of is a great overview of employers' compliance obligations as it relates to the COBRA subsidies. So step 1 logically then is who is responsible for providing premium relief to participants in claiming this tax credit, right? So who is responsible for what? And this chart summarizes when the employer, insurer, or the plan would be responsible for claiming the tax credit. So we see that fully insured employers subject to federal COBRA, self-insured employers subject to federal COBRA, the employer will be claiming the tax credit. The insurer claims the tax credit when you're dealing with a plan subject to state continuation, not federal COBRA. And then when we have multi-employer plans, it would be the plan that would claim the tax credit. When we're dealing with multiple employer welfare arrangements, or MEWAs, there isn't direct guidance. So this will come down to whether the MEWA is maintained on the plan or the employer level. And if it's on the plan level, it would most likely be the plan that's claiming the tax credit. If it's on the employer level, it would trickle down to each individual employer member. So as a good start there would be to review plan documents and see who is identified as the plan administrator and the plan sponsor. So step one. Now, we can't talk about who's responsible for providing premium relief to participants in claiming the tax credit without also talking about which plans are subject to the subsidy. So as a reminder, ARPA applies to all group health plans, fully insured and self-insured, providing medical benefits that are subject to federal or state continuation requirements. So what does that mean? Who is included in these group health plans? That would include medical, dental, vision, HRAs. It does not include, expressly does not include health FSAs. It could include an EAP or an employee assistance program if the EAP provides medical benefits and is otherwise subject to COBRA. So just a review there. So we know who is responsible for providing the premium relief to participants and which plans are subject to the ARPA COBRA subsidies. All right, moving along to step 2. Who are the assistance eligible individuals? So while this seems straightforward, if you haven't experienced yet, this is a lot of where the muddied water comes in, where we're getting continued conversations, continued questions about that really trickle down to who is an AEI. And so here's who are the assistance eligible individuals, and that would be your initial COBRA triggering event or reason for loss of coverage was involuntary termination of employment or reduction of hours. Okay. With involuntary termination, this is, I would argue, one of the questions that we're receiving the most of as it relates to application of ARPA to benefits administration, in really defining what involuntary termination is. And as we go through this presentation, we're going to address this in the Q&A section too, since it's such a heavy hitter of confusion. But to reiterate, involuntary termination of employment or reduction of hours and gross misconduct is an exception to offering COBRA. So really, as background, there is no offer of COBRA when it's termination due to gross misconduct. So taking it one step further, there would be no subsidy. Here, though, with determining what is gross misconduct, one should not confuse termination for cause with gross misconduct. This should really be a determination that outside counsel is advising on. It's really the most egregious. It's just a tough determination to make, and that should be done with the assistance of counsel. And we've received clarification on reduction of hours that it includes both involuntary and voluntary and can include leaves of absences, furlough, changes from full-time to part-time. So let's think here like a loss of coverage due to unpaid leave, extended medical leave, that's non-FMLA, can also include a no offer of coverage due to measuring under 30 hours in the most recent measurement period. So if you have a variable hour employee who in the most recent measurement period did not measure as full-time, they would receive an offer of COBRA due to reduction of hours. It could be eligible for the subsidy. So number 2, still in the maximum COBRA coverage period. So that's important too. You have to still be in your maximum COBRA coverage period. That's 18 months for federal COBRA coverage. State continuation can vary. For example, I believe, and I could be wrong with these numbers, but I believe New York is 36 months, Connecticut is 30 months. So it really just depends on the state, given the state continuation maximum coverage period requirement. And it also will include new COBRA qualified beneficiaries that experience a triggering event April through September. You cannot be eligible for other group health plan coverage, and you cannot be eligible for Medicare. So again, as you see, it's pretty straightforward on the 1, 2, 3, 4. Involuntary termination of employment or reduction of hours in your maximum coverage period. You're not eligible for other group health plan coverage, and you're not eligible for Medicare. But unfortunately, there are just a lot of gray areas when you're applying this, and we'll talk about that as Beth will give some practical application to employer scenarios, and we will dissect some Q&A. All right, so step 3. So we have step 1 and step 2. Step 1, who's responsible for receiving and claiming the tax credit. Step 2, who are the assistance eligible individuals. And step 3, the required notice. So as you may know, the ARPA requires certain notice requirements on behalf of the employer and individuals. Some of the notices, for purposes of this step, we have a variety. If I could spin this wheel, I would, but we have the wheel of notices, and we have a model general notice and COBRA continuation coverage election notice. We have model notice in connection with extended election period. We have the model alternative notice, and then a summary of COBRA premium assistance provisions under the American Rescue Plan Act of 2021. We will talk about the notice of expiration in a subsequent step. But here are, when we're talking about once you've identified the assistance eligible individuals, which notice is required, it would be one of the first 3 with the summary notice attached to one of the 3. And we'll talk about that in the next slide. So what does this do? Why is it important? Well, this is a notification that is going to let those assistance eligible individuals know their rights. So rights to receive a COBRA subsidy, if they have a right to elect COBRA, effective April 1, if they never elected COBRA or if they previously dropped COBRA. If the employer chooses to permit an option to switch coverage options, it would notify those assistance eligible individuals of all of those things. It would also include instructions for claiming those rights, and it would also ask and informs individuals to notify the plan if they become eligible for Medicare or other group health plan coverage, and penalties associated if they fail to do so. So with that in mind, let's go over who receives what with the notices. I also would encourage, if you haven't done so already, the DOL published model notices 2 weeks ago, maybe, and it's linked in this presentation under the resources slide that will be shared within 24 hours of us giving the presentation. So I really would recommend you reviewing the content of the notices. It provides helpful information and guidance there. So, and it starts by saying who receives which notice, so that's helpful too. But it's also summarized here in this handy dandy chart. AEIs who are currently enrolled in COBRA due to a qualifying event prior to April 1, and AEIs not currently enrolled in COBRA, but they're still in their maximum COBRA coverage period. So that could be because they didn't initially elect it or they dropped it for whatever reason. Those 2 groups of folks need to receive the model notice in connection with the extended election period. Qualified beneficiaries who have qualifying events between April 1 and September 30, so those who experience qualifying events of involuntary termination or a reduction of hours, would need to receive the model general notice and COBRA continuation coverage notice. And then the qualified beneficiaries enrolled in continuation coverage through state continuation would receive the model alternative notice. All of these notices should be accompanied by the summary of the COBRA premium assistance provisions under ARPA. Okay, so nice little snapshot of who receives what. There are a lot of notices that were released, and it can easily get confusing on what to do when. So it's also fair, if we're talking about, to send the notices not only to clarify who receives what notice, but also to summarize a little bit of the mechanics regarding sending the notices. So COBRA in general the rules are that you send the notices to the last known address on file. And if it's returned, that you would forward it if there is a forward address provided. Okay. And if qualified beneficiaries are known, if the employer knows that they have different or separate addresses, you would send separate notices in that instance. And then this also, just to clarify on who's responsible for sending these notices, generally it's the employer as the plan sponsor. For a MIWA or multi-plans that we discussed a couple slides ago, check the plan documents or the SPD. For state continuation, it's generally the employer. Sometimes state law says otherwise, but it's a conversation to have with the carrier. And then, of course, TPAs can be utilized, but it ultimately comes down to generally employer responsibility. All right, so once it's understood who receives what notice, and you have your notices in hand, a few things to keep in mind. That for those assistance eligible individuals not currently on COBRA, but still in their maximum coverage period, and for those AEIs who are currently on COBRA due to a qualifying event prior to April 1, they need to receive their notice by May 31st. And this is Memorial Day, so make sure the postmark is on or before Saturday, May 29th. Now, employees will have 60 days to elect and postmark return forms, but coverage would be retroactive to April 1. So timing requirements to keep in mind, if you haven't already discussed with your COBRA vendor, if you have any, if you administer COBRA in-house, this is something to be very mindful of, that there is notice obligations and there is timing that is frankly coming up quickly. And we'll talk about these in our examples as well. All right, now what will the qualified beneficiary need to do? The assistance eligible individual who is currently on COBRA, the model notice explains that you're to return the request for treatment as an assistance eligible individual. And this, for reference, is located on page 2 of that summary notice. And AEIs not currently on COBRA, the model notice explains that you return the request for treatment as an assistance eligible individual, as well as a COBRA election form. And the COBRA election form, for reference, is on page 6 of the extended election period notice. Now, I should clarify, explain, I don't know if this clarifies, but it appears unclear if the AEI is required to provide an attestation form, for example, the request for treatment as an assistance eligible individual. However, it is the process outlined in the model notice, and most employers utilize the model notices provided by the DOL. So keep in mind when we suggest to review the model notices that provides helpful information, you better understand, and it helps provide a better understanding of the processes that are elicited from those model notices. One is just exactly what we explained, is that it informs the individual that they need to return their request for treatment as an assistance eligible individual. If they are currently on COBRA, or if they're not currently on COBRA, they need to return the election form and the request for treatment as an assistance eligible individual. So it's clear that employers need to communicate with individual regarding the subsidy, eligibility, any steps to take to receive the subsidy, individual notice obligations. But we have been asked whether or not it's required to provide an attestation form, and it's, as mentioned, it still remains unclear. However, keep in mind, if those model notices are being utilized, it is the process that is explained. In addition, it will help create paperwork that might be necessary for the employer to provide during payroll tax, to receive the payroll tax credits. So bottom line is folks who are subsidy eligible and elect COBRA should be receiving the subsidy, and the employer should be communicating that accordingly. On to step 4 on the premium payment process. We are still awaiting further guidance on how the process for paying premiums works. And until then, and even through then, employers should work with their carriers and COBRA vendors. But a few reminders that might be helpful. Assistance eligible individuals should not be charged the premiums from April through September. In other words, AEIs are considered to be paid in full. The entity responsible for paying the premiums is entitled to the tax credit. And as a refresh of what we went over at the beginning of the presentation, the carrier would be receiving the tax credit for a fully insured plan that is not subject to federal COBRA, so think state continuation. The employer for all self-insured plans and fully insured plans that are subject to federal COBRA, and the plan for a multi-employer plan. So this can create some difficulties. For example, an employer with a fully insured plan subject to COBRA will likely have to front the premiums to the carrier for assistance eligible individuals and then receive the credit. So that is something for employers to be mindful of. And step 5 would be to send the expiration of premium assistance notice. So while we had the wheel of notices earlier, it did not include this notice because at that point in the stage, this notice did not need to be provided. But the regulation states that employers must notify assistance eligible individuals that the COBRA subsidy will end, when it will end, and the date it will end. They provide a model notice. The beginning of the notice is screenshotted here. It's also linked at the end of this presentation, but it must be provided within 15 to 45 days before the expiration of the COBRA subsidy. There are times when it is not required, and that's when an assistance eligible individual becomes eligible under a group health plan, excluding QSARAs, health FSAs, or accepted benefits, or Medicare. And so this notice functions to notify the assistance eligible individuals that the COBRA subsidy will expire and the actual date that the subsidy will end. It also provides information to those assistance eligible individuals regarding eligibility for coverage without premium assistance, whether it's through COBRA continuation coverage or under another group plan. It also notes that assistance eligible individuals and any covered dependents may be eligible for a special enrollment period to enroll in the individual market and health insurance coverage. Okay. Step 6, applying for the payroll tax credit. We are still awaiting further guidance on the process for obtaining this credit, but here's what we know now. The credit is calculated each calendar quarter with an amount equal to the premiums not paid by the qualified beneficiaries who qualify for the subsidy in that quarter. The credit is limited to the amount of the FICA tax. Now, there can be a credit advanced through the end of the most recent payroll period in the quarter. To reiterate, the amount of the credit equals the amount of premium plus administrative fees. That's usually 102% of the cost of the premium. We do not have any further definition of administrative fees, unfortunately. And note that if the employer is paying more in COBRA subsidies than it owes on employment taxes, then the IRS refunds the difference. This is probably better understood with an example. So if we have an employer that has to pay for COBRA for 10 qualified beneficiaries, and each one costs $1,000 for simple math, right? So they would be out of pocket $10,000. But they only owe $4,000 in employment taxes for the quarter. Then they don't have to pay the $4,000 in employment tax. That's their payroll tax credit. and that we get $6,000 cash back from the IRS to reflect the other $6,000 paid out under the subsidies. So that's the scenario where if the employer is paying more in COBRA subsidies than it would owe in employment taxes, that's where a refund comes in. But we are hoping for further guidance from the IRS on that. So that, thanks for bearing with me, is packaging all the compliance obligations into six steps, if you will. And I'm going to hand it over to Beth, who's going to lead us through some examples that do a nice practical application of those steps into what our employers are seeing in their day-to-day administration.
Thank you, Diane. Thank you for that kind of precursor to what the ARPA COBRA subsidies is going to require. And I thought it would be good now to kind of go through some practical application of that step-by-step analysis that Diane just gave. Fortunately, I was looking at a lot of the questions that came through in the Q&A box. And so instead of stopping now and kind of bringing up some of those questions, I will be able to, as I go through the practical application, just kind of answer some of those questions as they come up. And I'll also point out that after, we do practical application, we're going to return to kind of some COBRA FAQs that will also discuss some of the things that people have already asked. So first slide, Diane. So in the practical application section of today's presentation, I thought it would be good to kind of give you the story of a few employers, right? And the goal would be that anybody on this call kind of finds themselves or sees themselves in any one of these numbers of employers and realizes kind of how those 6 steps that Diane just laid out will actually work. Okay, so that's kind of the framework as to what the next several minutes will look like. And so with this first employer, it's XYZ employer, and this employer has 500 employees, okay? They sponsor a self-funded plan, and they actually self-administer their COBRA, okay? And so that means they do not have a COBRA vendor. They are actually the ones that were responsible or taking on the obligation to send out notices to employees and actually work with their TPA to get those persons enrolled in coverage. Now, as far as XYZ is concerned, over last year, they basically furloughed a number of their employees. And they have not had the occasion to bring those employees back. And so those employees just, basically were terminated in 2020. And they also have currently some qualified beneficiaries who are actually on COBRA. Okay, so a number of those might have been the employees that were furloughed. A number of those might be people who just potentially resigned or, let's say, experienced a divorce. So, as it pertains to the steps that Diane laid out, the first step is basically who pays the premium. And because we have a self-funded plan with 500 employees, we know that they are basically subject to federal COBRA because they have well more than 20 employees. And that means that XYZ employer is going to be responsible for actually providing the premium relief to the assistance eligible individuals. And they are also going to be the entity that claims the tax credits. Okay. Now, when it comes to steps 2 and who are the assistance eligible individuals, the facts that I gave you for XYZ employer is that they had a number of people who were furloughed. Okay. And when we talk about the idea of being furloughed, that generally means that the employer made the decision to let them go for the year. And it might have been, because the employer did not have business or because the employer had to close for a period of time. But the whole point there is that the employer actually initiated these people's termination. And so we're going to consider that an involuntary termination. And those furloughed employees would be assistance eligible individuals. And that would be whether or not they elected COBRA, right? So some of them, when they were furloughed, might have elected to continue COBRA last year. Some of them might not have. Additionally, the current qualifying beneficiaries who are actually on COBRA would be AEIs as well if they actually left the employer because they were involuntarily terminated or if they had their hours reduced. Okay, so those are going to be kind of the different people that would be potentially, AEIs as it pertains to XYZ employer. Now, with step 3, the employer is going to have to send the notice, right? So those furloughed employees and those who are actually currently on COBRA are going to receive the model notice in connection with extended election period. And so there was a few slides ago, where Diane actually laid out which notice goes to whom. And specifically, the notice that's going to go to those who were furloughed last year and who would potentially still be in their COBRA maximum duration period, as well as those people who are currently on COBRA if they were, received COBRA because they reduced their hours or were involuntarily terminated, are going to receive that model notice in connection with extended election period. Now, mind you, XYZ company is still out there, is still employing people, probably still terminating people. And so anyone that experiences a triggering event between now and April and September is going to receive the model general notice. And so that's slightly different because really this is their first crack at COBRA. And so they're not going to receive the same notice as the people who were already offered COBRA before and maybe turned it down and are coming back, or those who are already on COBRA. And then finally, because XYZ actually self-administers their own COBRA, they are going to spearhead basically the whole process of sending those election notice and identifying who the AEIs are, as well as actually sending out those notices. Next slide, Diane. And so in the final steps, really it has to do kind of, I will say at least 4 and 6 have to do with the premium itself. And I specifically wanted to include a self-funded employer because we have gotten a number of questions about kind of what that will look like for a self-funded employer. And so in this case, XYZ employer is self-funded. Right. And so it's not like there is technically a premium that is being paid to an insurer. Instead, XYZ employer is paying for their plan's claims out of their general assets, right? However, XYZ is going to claim the tax credit for the quote unquote premiums that they're basically not receiving from those people who are AEIs. And I bring this up to kind of point out the idea that all self-funded employers should already have a COBRA premium equivalent, right? And that is the amount that the employer is going to basically forego receiving from these COBRA AEIs. And they're going to basically, at that point, apply for a tax credit for the government to reflect that amount that they did not take essentially from that employee or that COBRA qualified beneficiary. Now, we got a few questions, a few times for self-funded employers to basically ask, well, what if the self-funded employer, has larger claims? Can we actually look at actual claims from these people? And the answer to that is no. The law is written to discuss this from the standpoint of assistance for the premium. Right. So just like in a regular plan where a self-funded plan is only going to take a certain amount of money in premiums for the employees, and then they're going to basically have to kick out any of the other money to pay the claims, that's going to be the same here because they're only going to get tax credits for the portion of it that would be considered, the COBRA premium equivalent. Step 5 switches back to notices, and this is actually kind of after some time has passed potentially. An XYZ employer is going to have to send notice to the COBRA qualified beneficiaries, notifying them that their subsidy is going to end. And again, that has to be sent 15 to 45 days before that subsidy ends. I think the timing of this will be really interesting depending on whether or not some of those furloughed employees, for example, are going to be kind of heading towards the end of their COBRA maximum duration period, but we'll talk about that a little bit more in a second. And then finally, the last step is that XYZ will work with their accountant to basically, hold on to their Medicare tax amounts and then potentially request a refund from the IRS. If, for example, the amounts that they have to kind of quote unquote pay out for these premiums exceed the amount of Medicare tax that would be due to the IRS. And so those are how the steps work for XYZ employer. Now, a few what ifs just to throw in some discussion. What if the furloughed employees have new jobs? If that's the case and they're eligible for coverage at their new employer, then they would not be eligible for a subsidy. And so it could mean that in XYZ's analysis, there are going to be some of those employees who receive this notice, but they are not going to actually be eligible to actually receive a subsidy. And they're going to just either not apply for it, or they may potentially apply and they have to certify, based on the forms that are provided, whether or not they have access or are eligible to new coverage. We've gotten the question of what if these employees who were furloughed return to XYZ, and that analysis is generally the same. If they return to XYZ and they're eligible for coverage now at XYZ, if they're going to get that back, then they're not going to be eligible for COBRA assistance. And so keep it in mind that it really just boils down to whether or not they're eligible for other group health plan coverage. Now, I already alluded to, the idea of what happens if some of the furloughed employees only have 3 months left of their COBRA maximum duration period. And so this would be, let's say, potentially people who were, maybe furloughed at the very beginning of 2020, who may have just a limited amount of time left in their COBRA maximum duration period. Those people would essentially, be eligible for that assistance, and then potentially, they would receive the notice that tells them that their COBRA subsidy assistance is going to end. And then finally, what happens if the furloughed employees fail to make their election within 60 days? Well, if they don't elect it, then they kind of waive it. That's the way that the rules were written on this. And so they could not come back, let's say 120 days later and say, oh, well, I do want COBRA, because kind of once they do not actually make that election, they waive it. So next slide, and we're going to talk about a different employer. And so this is ABC Employer. ABC Employer has 200 employees. They're a fully insured plan with the COBRA vendor. Last year, they only fired one person, and that was for gross misconduct. And they didn't have any employees who reduced their hours. But they do have currently some qualified beneficiaries on COBRA. Now, step one, who's going to pay the premium? In this case, ABC Employer is going to be responsible for providing that premium relief to the assistance eligible individuals, and they're going to claim the tax credit. Step two, who are the AEIs? Now, let's talk about this one person that was fired last year, because gross misconduct, if the person is fired for gross misconduct, that is not going to trigger COBRA, and it's also not going to allow the person to be eligible for ARPA subsidies. A couple of the questions that we've already seen in the Q&A had to do with kind of what's that definition of gross misconduct. And I will say that ERISA did not make this easy, because it didn't actually define gross misconduct. It kind of said to look at state law, and then to make it even harder, a lot of state laws don't even necessarily accurately define gross misconduct. But we caution employers here to make sure that if you are making that argument that you fired someone for gross misconduct, or that you are not going to give them the COBRA subsidy because they were terminated for gross misconduct, it usually goes a long way if you have an attorney who actually told you that it was gross misconduct, because employers' ideas of what gross misconduct is don't necessarily rise to that threshold. We get a lot of employers who ask things about, oh, we had a no call, no show. Is that gross misconduct? Or, oh, we had someone who, was a poor performer. Is that gross misconduct? And based on the case law we have around this, those are not it. Okay. And so you just want to be very careful if you're making that decision, because if you make the wrong decision, then you could find yourself on the receiving end of kind of a notice from the DOL. Now, current COBRA QBs could potentially be AEIs again, as long as their COBRA triggering event was that their hours are reduced or that they were involuntarily terminated. So as it pertains to step three, the current COBRA qualified beneficiaries are going to receive that model notice in connection with extended election period that we've also already talked about. Also, anyone that experiences a triggering event from April to September is going to receive that model general notice. But mind you, other than that, there's not going to be necessarily a requirement to provide those notices to anyone else in this regard, because they only kind of had one person that was terminated last year. I know obviously they're going to have to look back until October, I think 2019, but being a smaller employer, in this case, ABC Employer, just hasn't had a lot of people leave. But since ABC has a COBRA vendor, they're going to work with their vendor to basically identify those AEIs. And then the vendor will probably send out the notice, because a lot of COBRA vendors have said that they would be willing to do that. Next slide. Steps 4 through 6, also a little bit easier somewhat in this regard. ABC is going to actually remit the payment to the insurer for the AEIs who are entitled to assistance. And so we got a couple questions in the box about that as well, about like, how does that work? Where do we get this money from? And the reality is that, at any given month, even without COBRA subsidies, the employer is paying the insurer the cost of those premiums. Now, they're also receiving, let's say, participant contributions, and depending on the amount of the participant contributions, it may be a very large amount that the employer is used to receiving, but that's where those payroll tax credits are going to come in supplementing the money that the employer might have to pay over to the insurer that they are not receiving from participants. In step 5, the requirement to send the notice of expiration of premium assistance That is going to be, again, due 15 to 45 days before those COBRA qualified beneficiaries might have their subsidy end. And then finally, ABC is going to potentially work with their accountant, again, to either hold on to their Medicare tax amounts and kind of do the due diligence to find out what those amounts are, and then potentially request a refund from the IRS, for example, if the amount of the Medicare tax does not actually rise to the level of reflecting all of the monies that they expend on premiums. Next slide. All right, so what if? What if the person that was fired was actually fired for poor performance? Again, I already kind of went to this of like you want to be very careful in deciding what gross misconduct is because poor performance is probably not enough. And you want to be very careful that if you did not offer them COBRA the first time because you thought that maybe gross misconduct could be poor performance, that you really rethink whether that's appropriate to do with these COBRA subsidies. Kind of along the same lines, what if ABC did offer COBRA to the person because they were fired, but now they don't want to provide the subsidies to that person because now they want to assert, oh, well, we fired them for gross misconduct. It's going to be best if the reason that you terminated them and whether you offered them COBRA on the front end is going to match your argument that they, should not get the subsidy because they were fired for gross misconduct. If they don't match, that probably, indicates that on one of those sides, your analysis of whether or not the person's firing was for gross misconduct was inappropriate. So be careful there. What if the COBRA vendor is going to charge or the employer to send out the required notices? And this is a question that we've gotten in the box as well, because the question kind of had to do with whether or not the tax credits could cover potentially the cost of administering COBRA in this regard. The law didn't really do us a lot of favors. They did put in the definition of the premium that it could include administrative fees, but they didn't go any further than that. So they didn't really say like admin fees are, yes, the cost to mail it. And so we're hoping maybe that we'll get some additional guidance from like that from when the IRS provides us guidance. And then this last question, I just threw it in there to kind of throw in a wrench that, compliance people have a hard time with. So let's say that ABC actually left a PEO in January of 2021. And let's say a lot of or whoever was fired last year was fired at a time when there was a PEO in place that might have offered COBRA. Kind of what does that look like? And I'm just going to be honest here, that is going to be a very facts and circumstances based issue. And we definitely recommend that employers in that situation, consult with legal counsel, consult with the PEO. And I think at the end of the day, the important thing is just to make sure that any AEI that was your employee is going to be offered the opportunity to come back and enroll in COBRA from someone, right? So we just don't want there to be a scenario where there's a block of people out there who are not receiving their offer to enroll in COBRA from the employer, but are not also receiving it from, let's say, the PEO that the employer is relying on to do that. Next slide, and the last example of LMN employer. LMN employer is slightly different. They have 18 employees in Texas, and so that 18 tells you they're not subject to federal COBRA, right? It's a fully insured plan that works with OP Insurance. Last year, they laid off some employees, and none of them actually chose state continuation, but they do currently have 3 employees who are on state continuation right now, and we'll assume that they're going to be on it for some portion of the period from April to September. Now, in this case, because this employer is subject to state continuation, OP Insurance is responsible for providing that premium relief, and they're going to claim the tax credit. Right, so that's the difference there. Who are the assistance eligible individuals? In this case, employees who chose not to enroll in the state continuation actually don't have the opportunity to elect continuation now. And this is something we realized after we got the DOL's guidance, because they had a couple questions that made it kind of clear that the opportunity to come now and elect COBRA coverage, let's say if you had waived it before, doesn't actually apply on the state continuation. And so what that really means is that only people who are currently on state continuation are going to be considered assistance eligible individuals for the remainder of whatever their state continuation coverage is, assuming it ends before September. And even that is going to be if they experienced a reduction in hours or were involuntarily terminated. And so, in this regard, as it pertains to notices, LMN is probably going to have the obligation to notify those continuation participants that they may be eligible for assistance, because the law does not seem to actually require the insurer to meet the notice requirements as much as the employer has to. But these employees are going to receive the model alternative notice because they are on state continuation. Next slide. And then, as far as there we go, next slide. As far as the last steps, again, different because this particular employee is a small one. And as far as the premium is concerned, our understanding, or hope at least, is that OP Insurance is actually not going to charge these continuation participants, right? And is not going to charge that small employer either. Now, hopefully that's how insurance companies are going to deal with this. Could there be some that say, okay, employer, you're going to pay us this and then we reimburse you? Or I don't know. The mechanics of that I think are going to be interesting. But our understanding is going to be that the insurance company, would potentially just reflect that those participants' coverage has been paid. And then also, Element is going to seemingly not owe, OP for that coverage, right? Because that's coverage, hopefully, that's between the insurer and that state continuation employee. Like I said, that's how we hope that it's going to work, but we could see some issues where, mechanically that's slightly different. And then, as far as the notice of the expiration of premium assistance, it's still the same idea that Element is going to be responsible for sending that notice to the people on state continuation. I think this could also get weird, right? Because, depending on how much information Element has after those people enrolled in state continuation, they may not even actually know kind of who's on it and who's not. And so, I think that there's definitely going to be some collaboration there between small companies and their insurer in that regard. But then ultimately, the insurance company is who's going to apply for the tax credit for the subsidies. And so that's how that would work. So let's go on to kind of just some quick what if questions for this particular employees. So, what if employees who left without electing state continuation want to come back and elect state continuation now? And that's something we tried to make clear, which is that the law seems to indicate that those who did not elect state continuation would not now have a special kind of enrollment opportunity, if you will, to come back and elect it. And we feel like the DOL's FAQs made that clear. Now, what if LMN has a QSARA? So they have a qualified small employer health reimbursement arrangement. These COBRA subsidies specifically exclude QSARAs. So they're not actually offering these subsidies for a QSARA. And a QSARA is already somewhat different because it's actually the employer just providing employer contributions to someone to go out and get individual coverage, for example. And so in that regard, the employer is submitting that and the employee is not necessarily paying them for that benefit anyway. And then finally, what if Element stopped sponsoring a plan? And this actually, I put this for Element, but this could actually go for any of those employers. Let's say any of those employers wind down, or let's say that they stop sponsoring a plan, a group health plan altogether. Then the obligation to provide COBRA actually stops when you stop offering a group health plan. And so keep in mind that aspect of COBRA still seems to be in place. And if you do have a situation where a company is winding down, then potentially they would not be required to continue to offer these COBRA subsidies if they don't have a group health plan in place. Now, as long as there is a group health plan in place, they would be required to cover it. So, for example, let's say that they did a graded approach to shutting down where they laid off 14 people. Then potentially, those people who left would be entitled to state continuation as long as there's a plan left that still covers those other 4 people. Now, once there is no longer a plan, then potentially that requirement is going to stop. So those are our practical application points. Diane, anything you saw in kind of the Q&A as I was talking that you think, is worth bringing up?
Yeah, I was going to ask Patrick if he had any questions that he thought we should address before we get into our FAQs.
Hi, guys. We've gotten a couple of questions. The trends seem to be along the lines of, what if the employee does X? Does that count as an involuntary termination?
Okay.
The thing to reemphasize what we consider to be involuntary terminations for this purpose.
That's a great question. That's actually our first FAQ in talking about involuntary termination is unfortunately not further defined. So some of that equation that you're sharing with us, if the employee does this, does it mean involuntary termination? It isn't black and white, and it's not something that we are able to make that determination of. We do have prior guidance from 2009, I think it is, Beth, that provides some guidance, but it's still not, we're not able to make an absolute determination. So on that point, Patrick, Beth, I'm going to put us on the spot because I'm going to say the caveat here. I don't know the answer to this question I'm about to ask, but I did see one Q&A ask if we have an employee who is no call, no show, is that voluntary termination or involuntary termination? So that's an example of what, I've been debating.
Well, so interestingly, and I think we've addressed this before, and it's actually a situation to put Chase on blast a little bit. It's a situation where we kind of answered it one way because we're like, oh, well, maybe, it could be considered as them quitting because they no call, no show. But you have to peel back some more layers because there are some states that actually speak to no call, no shows, and kind of their analysis of it lines up with how unemployment works. And so the point there is that it's not just a matter of the employer saying, oh, we think a no call, no show is considered, voluntary. That actually brings up other kind of employment implications that we can't necessarily speak to. And so, like I said, I just think employers should be very, very cautious in proceeding on some of those questions of what involuntary termination means when there's this gray that we're not sure about yet.
I agree. Well, Patrick, with that, I'm sure there are other questions, but I would like to keep talking about involuntary termination. So we'll give you a nudge here in a few slides to chime in if there are other Q&As that we should be addressing.
Sounds good.
Thank you. All right, so thanks, Beth, for going over kind of that practical application of those step-by-step processes. I think it's very helpful. Now to move into the frequently asked questions that we are still receiving. I would venture to say between our team, we're still receiving dozens of questions a day. It's just, as the material we've gone through, it might be straightforward at first glance, but then if you start peeling back the layers, it gets very muddied. So hopefully we can clear up some things, or at least have a conversation on those continually asked questions. And as Patrick right out the gate brought it up, is that what does involuntary termination include? Does it include a former employee terminated for cause? Does it include a former employee who had a known contract end date? So for example, somebody was hired June 1, 2020, and anticipated end date June 1, 2021. Does it include former employees who are encouraged to voluntarily terminate employment and accept a severance package in light of their employment likely terminating in the near future? So these are just a fraction of the instances that we've been seeing. In addition to, I'm sure you all have been fielding other questions similar to this. Now, as Beth and I just discussed with the question that Patrick elicited, it's unclear how involuntary termination of employment is defined. And it often will depend on the particular facts and circumstances. So with that, getting guidance from counsel is likely your best option here. Now, there might be a more expansive definition adopted by the regulators given the COVID-19 ongoing pandemic, but we just don't have that guidance. So before I go into a healthy discussion on each one of these bullets, just a reminder on what we've gone through is that to be eligible for the subsidy, a qualified beneficiary must have experienced a reduction of hours or involuntary termination of employment. So that's why we're really getting to the crux of, well, what is involuntary termination? And if you will, with me, go back to the basics for a minute, I also think it's fair to reiterate who a qualified beneficiary is. And so as an aside, while we're focusing on those individuals who are involuntarily terminated, because it is causing a lot of confusion in application for ARPA, we should really keep in mind that to be eligible for COBRA, an individual has to be enrolled in coverage on the day before that triggering event. So an individual would need to be enrolled in coverage on the day before the triggering event. And in this instance, when we're dealing with COBRA subsidies for ARPA, enrolled in coverage on the day before coverage was termed due to involuntary termination or coverage was termed due to reduction of hours. So said another way, if an individual experienced these two events and was not enrolled in coverage the day prior to the event, they are not a COBRA qualified beneficiary. They would not receive an offer of COBRA, and they would not be eligible for the subsidy. Sometimes we get so down into the weeds that we forget to go back to the beginning and realize what we're dealing with here. So I'll get back off of that soapbox on the basics and go into some involuntary termination examples. So let's talk about termination for cause. Beth brought this up. I brought it up at the beginning too, but Beth elaborated that termination for cause is likely involuntary termination unless it's considered gross misconduct. And as we've said throughout, that is a determination that should be made with the assistance of counsel, and it often includes the most flagrant or severe actions. Okay, so don't confuse termination for cause with gross misconduct. You have what else do we have here? Former employee who has a known contract period end date. So the example I gave is that somebody was hired for 1 year. My first job out of law school was a fellowship. I had my end date before I had my start date. This is unclear. We have prior guidance from 2009 that does explain a little bit, but we don't have any guidance specific to ARPA. So what we have from prior guidance on IRS Notice 2009-27 is that involuntary termination was defined as employer-initiated separation from employment other than due to employee request when the employee is willing and able to continue services. The notice went on to explain that this includes an employer's failure to renew a contract at the time the contract expired if the employee is willing and able to execute a new contract with similar terms and to continue providing services. So while that might cause argument for that to be an involuntary termination, somebody hired with a known contract period, unfortunately, we just can't make that determination, and without any current guidance on the ARPA COBRA subsidies, it's unclear. But if we look back to prior guidance, that is the information that was provided, and that can help shape. Hopefully, we'll get some guidance here soon-ish. All right, what else do we have? Former employees who were encouraged to voluntarily terminate employment and accept a severance package in light of their employment likely terminating in the near future. I said another instance like this would be somebody who was strongly encouraged to retire early. Now, the similar answer here, folks, it's unclear. But if we look to prior guidance regarding COBRA subsidies from 2009, the guidance did provide that even if the leave was designated voluntary or a resignation, if the facts indicate that absent the voluntary termination, the employer would have terminated the employee, and the employee had knowledge that he or she would have been terminated, then that constitutes involuntary termination. So I'm not trying to muddy the water with prior guidance that we can't apply definitively now, but it does give you some sense of what the IRS provided for clarification with the last go of COBRA subsidies. We do not have current guidance specific to the definition of involuntary termination for the COBRA ARPA subsidies, but it's continued issue as we're applying areas we're administering benefits, but we unfortunately don't have definitive information to make those determinations. And because of that, we strongly would suggest that you consult with counsel on these nuanced situations. All right, Beth, what's our next FAQ?
Sure. So I love it, and I'm sure you all love it when we tell you we don't know the answer. But this question has to do with kind of what it means to be eligible for other group health plan coverage. And so the question is, if an individual waived group health plan coverage and is otherwise not eligible for such group health plan coverage until the next open enrollment, is the individual an assistance eligible individual? And it's unfortunate because, again, the law did not actually define what it means to be eligible for other group health plan coverage. There's an argument that, if the person can actually go and get coverage right now, then they're not eligible. But we're not quite sure, what the government was thinking in that regard, and whether or not they were even considering that there would be some people who might have, let's say, become eligible, but might have waived that coverage, let's say, due to cost, and can't now go get back on it, right? And so we'll have to wait and see if they tell us, what their thoughts were on that. But, keep in mind that in order to be eligible for the subsidies, that person has to have been, obviously, had a reduction in hours or an involuntary termination other than gross misconduct. They cannot be eligible for other group health coverage or Medicare, and they have to be within their COBRA maximum coverage period. I think we also saw a couple questions from employers who basically asked, okay, if we know, for example, that they're eligible for Medicare, does that mean that we don't have to send them the notice? And surprisingly, it doesn't necessarily mean you don't have to send them the notice, right? Because nothing in the notice portion of the laws and the guidance that we have had made it seem like an employer could just choose not to send the notice to someone who they thought was ineligible. Instead, it's that employees or individuals, obligation to say, I'm not eligible, and either not apply or potentially not give you a fraudulent election form. And so we still think that even if you have reason to know or to think that these people are eligible, you still want to send them the notice, and then it's up to them not to take it, if you will. Go ahead with the next question, Diane.
Yeah, thanks, Beth.
Mm-hmm.
So we've addressed this in both of the prior segments, but it's important enough that we want to, and frankly, it's a question that we've been receiving frequently, so it landed itself in our frequently asked questions section. How does the special election period apply to AEIs that are eligible for state continuation? And this was summarized in the step-by-step review, as well as through Beth's examples. To reiterate, only AEIs enrolled in state continuation during April 1 through September 30 are eligible for the ARPA subsidy. No special election period is applicable for state continuation with the information that we have currently. So AEIs eligible for state continuation, though, are able to switch coverage options if the employer permits, with the caveat being that the new coverage cannot be any more expensive than the prior coverage. But when the DOL FAQs came out, number 6 explains that the ARPA does not change any of the requirements or timing for election for state continuation coverage. So that being said, so why are we talking about this so much? Mostly, it's because there's confusion over identifying assistance eligible individuals. So when trying to identify assistance eligible individuals, when state continuation is applicable, you're dealing with those who are currently enrolled or will become enrolled or eligible during April 1 through September 30. So there's no look back, so to speak, to see for individuals who would have a special election right. And that is because they do not have one. And we just wanted to clarify that. So as a reminder, ARPA provides that an additional COBRA election period for certain qualified beneficiaries exists. It does not apply to state continuation. It does apply for federal COBRA for those who are premium subsidy eligible and still within their 18-month coverage period, but declined COBRA, or who dropped COBRA for any reason before the end of their maximum COBRA coverage period. All right, Beth.
All right. Okay. And so we addressed, like I said, like Diane just said, we kind of addressed some of these in our conversation. But this question is basically who sends and receives notices when an assistance eligible individual is enrolled in state continuation, right? And again, our understanding of the law is basically that the employer is going to be the one that's going to be responsible for complying with the notice requirements. It could, state law could potentially come into play, right? So, like, for example, each of the divisions of insurance might have specific rules for state continuation for these smaller groups. But our understanding, at least under ARPA, would be that those employers are going to want to make sure that those notices are being sent out. So, like I said, at the very least, there should be some communication back and forth between these smaller employers and whatever insurer they have, just to make sure they understand who is going to take on that obligation of sending the notices. But again, AEIs in this regard are really going to be the people who are actually enrolled in state continuation between April and September. And they're going to get that model alternative notice in addition to the summary form being attached. And so, like I said, I think this is really just a situation where those smaller employers are going to want to work with their carriers and to make sure that they are providing, updated information about kind of how those people were terminated, if they were terminated, so that the insurer is even able to identify who is who.
Thank you. All right, so what is the process for AEIs to receive the ARPA COBRA subsidy? And again, we addressed this best through the examples and through the review, but it landed in the frequently asked questions because it is a frequently asked question. So if we have an AEI who's elected COBRA, they're not charged the premium for the applicable months in the COBRA subsidy coverage period. Now, the model notice, which most employers are utilizing, explains that AEIs should return a request for treatment as an assistance eligible individual form. And AEIs not currently receiving COBRA would need to be notified of their special election right. And the notice then explains that those individuals would return an election form, and that's within 60 days of receipt of the notice, and should return request for treatment as an assistance eligible individual form along with the election form. So as we stated earlier in the presentation, employers should be sure to communicate with employees regarding the availability of the subsidy and the process to receive it and any individual obligations related to the subsidy. And reiterating that whether or not a form is required remains unclear, but it is the process that's outlined in the model notice, which most employers are using. And as previously mentioned, this will help the employer assist in record keeping and likely substantiation for the payroll tax credit. All right, and then keep in mind that employers do still need to identify which qualified beneficiaries are AEIs, and employers would have to coordinate with COBRA vendor if a COBRA vendor is being used.
All right. So the next question is, how are the ARPA payroll tax credits claimed? Okay. And we got a few questions about this. And just to kind of, again, make it completely clear, it's going to be claimed through a refundable payroll tax credit. Now, mind you, the law, if you get into the weeds, it's specifically the Medicare portion of kind of what we all know as FICA taxes, if you will. And depending on what articles you read, you might even hear it be referred to as like the hospital tax credit. But just keep in mind that generally that employer is going to claim the tax credit for both, insured premiums or self-insured premiums through the employer's quarterly tax return. That's how they would do that. And again, that's going to be the carrier for those small plans. And we're looking, obviously for the IRS to provide guidance on how this is going to work, right? I think specifically in regards to kind of what employers are going to have to be able to prove, that them providing a subsidy was appropriate. But we just don't have that yet. And, Diane said on the front end that, we don't know that we're going to have a part 5 yet of this ARPA webinar series. But as soon as we do get guidance from the IRS, we will put together something to share with you all concerning what the IRS says on those requirements. And so really it's just going to be key for employers to work with their tax advisors or accountants, as they're applying for those tax credits, and to further kind of peel back the onion on that. If you have an accountant or a tax advisor that is not as familiar with employee benefits and these tax credits, then it really does behoove you to kind of, talk to them about that and maybe provide even some of the, resources that we are providing to you as clients of NFP, so that they kind of have an idea of what, is going on there. Now, most accountants and tax advisors have their own continuing education requirements, and do have to kind of be briefed on these type of things. And so I would expect for a lot of them to kind of know that this is going on and know what that's going to look like. But just kind of understand that working with that tax advisor to apply for those credits in the way that's going to be appropriate for your business is going to be key.
All right. Thank you. We have a few more FAQs related to FFCRA and DCAP. And before we get into those quickly, Patrick, any Q&As you think we should address before we get into those?
Actually, I think you guys have addressed most of the questions that have been coming up in one form or another. One question that I saw that just might be worth touching on really briefly. When you send out the notices, particularly like the notice for the elections, do you send those by regular mail or certified mail?
So the interesting thing about sending mail period is the DOL and the IRS recognize regular old-fashioned first class mail. Okay. However, I will say, as someone who used to be an investigator and come out and ask people for proof of them sending a document, the first class mail doesn't always give you anything that shows that you mailed it. Right. And so, yes, if you can afford for there to be, let's say, certified mail or something that shows, what was sent to whom, that is going to generally be a good idea. And the post office has actually, if you use the post office anyway, has a couple different ways that they can provide you with certain documentation of who received a mailing on a particular date. And so, yes, obviously having more proof of documentation is always better, but the IRS and DOL really only require you to just send it basically first class mail, potentially. Good question, Patrick.
Yeah, and I'll also just throw in that especially when you've got 60 days from the date of receipt of the notice.
Oh, yeah.
That's something like certified mail will help establish when someone has received it.
Yeah, now the mailbox rule actually applies, but it's okay. Sorry.
All right. Yeah. So a few other questions, and this one, while the question isn't directly related, I do want to bring up, and Beth, maybe you can chime in a little bit. There was guidance released by the IRS today or recently regarding FFCRA paid leave. From my review of it, Beth, I didn't see that it was any new information, just that it was reiterating how employers can claim the credit related to paid leave provided under the FFCRA. Did you notice anything worth mentioning?
Yeah, nothing really new. It just looked like the IRS was kind of laying out kind of how you go about claiming that credit and kind of how much it's for. And to be honest, it wasn't even that different from what we kind of first received from them with the regular iteration of the FFCRA. But it just seemed like a publication where they were kind of making it clear that, those reasons for taking leave under the FFCRA include vaccination as well.
Okay, thank you. So with FFCRA on the mind, how did the ARPA modify FFCRA paid leave? So reasons for EPSL now include time taken to wait for COVID test results and to receive a vaccine or recover from illness related to the vaccine. In addition, ARPA grants an additional 80 hours of EPSL, and employees can now use EFMLA for any of the EPSL reasons, and the first 10 days of EFMLA can now be paid, and the maximum leave is increased to $12,000. it was $10,000. So here it's just pointing out the enhancements, if you will, that ARPA provided for FFCRA paid leave, and reminding that it is an employer's choice to provide paid leave per FFCRA and how ARPA modified FFCRA. And this can be from April 1, 2021 through September 31. If an employer chooses to provide leave, it is eligible for a tax credit for doing so. And lastly, to round out our presentation today, how does the DCAP exclusion increase impact non-calendar year plans that choose to increase the DCAP contribution limit? Okay, so a little background here, in that generally speaking, the DCAP exclusion amount is capped at $5,000. ARPA provides a temporary increase to $10,500 or $5,250 if the employee is married filing separately for taxable years beginning after December 30, 2020 and before January 1, 2022. In other words, the 2021 calendar year. So for 2021, there's a temporary increase in the amount of income that can be excluded, or the amount that can be excluded from taxable income to $10,500. Because it's applied on a calendar year basis, it elicits a lot of questions from those who have a non-calendar year DCAP. So, first and foremost, without any further guidance on this, a participant taking advantage of the increased DCAP contribution should be mindful that as of now, DCAP contribution limit for 2022 reverts back to that $5,000, and it cannot exceed $5,000 for 2022 calendar year. So for the next calendar year, for the 2022 calendar year, which a non-calendar year would bleed into, so if you have a June 1 plan year, June 1, 2021 to May 30, 2022, I hope I got that right, there could be some implications, and that's what employers who are sponsoring non-calendar year DCAPs are thinking about when they're thinking about increasing participants' ability to contribute to their DCAP. So for 2022, an employer might be able to allow employees to make a mid-year election change, so to decrease their contribution, and this would be based on the fact that there's a significant curtailment of coverage if permitted by the Section 125 plan. A little bit of background there. So because this increase is only for calendar year 2021, right now, without any further guidance, 2022 goes back to $5,000. The plan would change. So right now, if an employer provides an increased contribution amount in 2021, he would have to curtail or decrease benefits in 2022 because the annual exclusion is $5,000, goes back to $5,000. That could signify a qualifying event for individuals to be able to change their election amount to not over contribute for the 2022 plan year. If that would not be permitted, or if it's not an option, it may mean that participants will need to make adjustments on their election amount for the plan year beginning in 2022 to account for contributions already made. A lot of numbers were thrown out here. So the bottom line is that participants will need to be mindful of contributions in 2022 not to exceed $5,000, otherwise they would be taxed on them. Without any further guidance, that's the information we have right now. And that's not to say, not to muddy the waters more, but that's not to say that the DCAP temporary exclusion might be continued. There might be an extension of it. But right now, it's slated for 2022 to go back to $5,000. And it is something that non-calendar year DCAP plans should be aware of, especially if you're considering increasing your contribution amount to $10,500. All right, so with that, we put together some resources that have been made available since ARPA was passed. We have the plan itself, or the act itself, the FAQs, model notices, and some internal resources NFP has produced. Beth, I don't know if you have anything to add before we check in with Patrick one more time.
Really quickly on the FFCRA piece on that leave, we got a few questions about the documentation that employers can request if someone wants to take that leave, let's say because they have a vaccine or are sick from the vaccine. And it's important here to remember that it's our understanding on documentation that the rules of what an employer can ask for are the same rules that the DOL and the IRS put out basically last year when FFCRA came out. And so in that regard, you can ask the employee to tell you their name and contact information. And you can potentially, depending on the reason, ask them for the name of their doctor, but you could not ask them for a doctor's note. And the guidance around that last year kind of made it clear that with everything going on with the pandemic, we don't necessarily want to bog down doctors with having to provide employers with certifications kind of for this. And so, that guidance did not allow an employer to, let's say, require someone to get a doctor's note for that. And I'm not aware that that has changed any with the extension of the FFCRA, but I invite the team to kind of, speak up if their understanding is different.
That is my understanding too.
Oh, sorry.
Yeah. And the IRS has, I apologize because I haven't looked into it in a minute, but I believe the IRS has some detailed FAQs on the documentation that can be utilized.
Yeah. But I think that's all that I saw that needed to be addressed.
All right. Well, I guess, Leanne, we'll kick it back to you and give you all 8 minutes back in your day.
Perfect. Thank you, Diane, and thank you, Beth, for sharing your valuable time and your expertise with us today. Also want to extend a big thank you to our entire benefits compliance team for not only moderating the Q&A today, but as this is our final session of our scheduled ARPA webinar sessions. I do also want to thank you to the entire team for all the work that has gone into the previous 3 sessions. We know that a lot of time and effort went into reviewing guidance to make sure that we could put on this webinar series. So as a quick reminder to our audience, today's presentation was recorded and it will be emailed out tomorrow morning. The recording of the slide deck from this webinar will be posted to the nfp.com latest insights page under webinars/training. And all 3 previous recordings and slide decks are available on that same webpage. That concludes our webinar for today. Thank you all so much for joining us and have a great day.